Equality is never achieved through equal treatment.
The officials have been asked in parallel to this process to be working on implementation of a referendum approach.
And our nurses that gave evidence clearly demonstrated Māori are not given preference within a health system.
Do you think that Te Tiriti o Waitangi gives every person in this country the constitutional right to be here?
The political judgment has been made to bring this legislation to the House, and notwithstanding the so far majority commitments that it won't survive a second reading, nevertheless you have several months of work ahead of you as committee members to consider submissions and to hear from no doubt hundreds of people. So I acknowledge the work ahead of you, each of you, and indeed of this Parliament, and say that your task is an important one. I've kept my written submission as brief as I could. There's only one other point I'd really like to make. It somewhat draws on the points made in my submission. And that again is a response to some of the public commentary that has been around for a while, but it's been sort of elevated more recently by sponsors and supporters of the bill, that somehow this bill acts to rectify or correct the fact that there are not equal rights for all New Zealanders in Aotearoa, New Zealand. And in fact, if you look at the ACT Party website and the special website they've set up on treaty issues, they use that language, that not everybody is treated equally. The point I want to make is that those comments imply or assume that rights are not presently equal or not equally enforced or upheld, and that the treaty represents a source of inequality. And I just want to say that must be totally rejected. The treaty, if it represents anything, is a recognition of pre-existing rights, the pre-existing rights and interests of Māori and the promised protection of them. And the journey we've been on is not only to see a wholesale and egregious breach of those rights over decades and decades, but in the last 50 or so years, the journey of reconciliation and restoration, as we come to understand the treaty, its importance, the fact that it was breached, and that there must be some redress. Correcting wrongs does not create inequality. It restores the situation to what it was or should have been. To deny the ability to uphold the terms of the treaty would itself be an act of inequality, and it would make treaty rights secondary or inferior to any other legal rights, and would therefore make Māori unequal before the law. And to the extent that this bill claims to address that, it is not addressing anything at all. And it's for that reason that my preference would be to see the bill not continue. So those are the remarks I want to make. Happy to take questions.
I want to draw on, and we've had a lot of submitters, really great kōrero about the legality, the framework of Te Tiriti. I'd like to delve into your experience on reconciling with iwi whose natural development was interfered with quite horrifically. And in that experience for the rest of Aotearoa, if you could share with us, did you sense any violence, any hatred, any non-love for their whole nationhood And in that reconciliation, as you were trying to restore interrupted rights and obligations, what was your sense of the future and the sense of the spirit and the thinking of many of those hapu and iwi and looking forward?
I think the reflection I had was often, given the harm done to Māori, and not just, the land confiscation is pretty serious. Shooting and killing people is pretty serious too. Failing to provide protection, causing Māori have to leave their rohe, their areas that they whakapapa to in order to survive economically. Those are huge intrusions. I think what I reflected on was the extraordinary patience that Māori have shown. I think largely because of faith in the treaty, but also faith in the Crown. And if you think about the Māori's early relationship with the Crown, the pre-treaty relationship between Māori and the Crown, and Hongi Hiki visiting the UK, meeting King William IV, Māori's relationship with the British Crown, well predates any New Zealand representation of the Crown. And my sense was that it's Māori's faith ultimately in the Crown to deliver on the promise that it made in the treaty that held Māori together, focus on the objective of having a living treaty that was truly honoured. And so there was no sense of, splitting New Zealand asunder, far from it. It was recognising everybody's place in it. The place for Māori, as reflected in the treaty, and the place for all newcomers to Aotearoa, New Zealand as well. The treaty, in my view, is a unifying document. When understood and when its historical context is understood, and we should embrace it on those terms.
Thank you, Andrew. We probably have time for one quick question from Glenn. Kia ora. Hi, Andrew. Ngāti Rangi called this a distraction. Jane Kelsey called this a political stunt. We're here because of a coalition agreement between ACT and National Party. What do you see the politics of this bill? I prefer to not engage in. I've done my time in politics, thoroughly enjoyed every second of it. The political judgments of the day get made. It is what it is. I think what I hope I get to bring from the benefit of my knowledge and experience, particularly experience as a minister and as a Minister of Treaty Waitangi negotiations, are some insights that help to understand the treaty and its place and the future of Aotearoa New Zealand under it.
Freedom under the law doesn't guarantee wealth. It doesn't guarantee material equality. But what it does just so happen to do across a range of times, cultures and places is create the best opportunities in human history for disadvantaged people to achieve prosperity. This bill, some will say, may not pass this time. We shall see.
I've got a very brief submission to make on behalf of the Bar Association, which is, if you like, the independent bar version of the Law Society, has about 1,200 members. You have the submission. I don't intend to refer to it at any length, simply to make the point that above all the bill is misconceived because it endeavours to raise a number of principles that simply do not reflect the relationship of the Treaty of Waitangi between the Crown and tangata whenua.
Some submitters this morning, we've heard that this bill is required because our judges are not democratically elected as opposed to us politicians. I'm interested to hear your views on that, specifically on whether or not that undercuts some of the key separation of power doctrines that underpin our system.
Oh, but you hear these comments every once in a while. When the first Ngāti Apa decision came out in 2002, there were all sorts of screams about activist judges and so on. In actual fact, the decision was in line with ancient principles of common law. So I don't pay too much attention to that kind of debate. And the last thing we want in this country, Ms. Anderson, is a politicisation of the judicial appointments process, which has worked incredibly well, regardless of Labor or national administrations. Attorneys General I have known over the years have always done their best to appoint judges who will do justice and administer the law. And the last thing we want in this country is sort of confirmation hearings like happened in the United States Senate with Brett Kavanaugh. So I pay no attention to those sorts of comments because they're meaningless. We have the best system of appointment of judges in New Zealand. We have a judiciary that is extremely talented and hardworking, and we don't want to go down that path of attacking the judiciary as happens in the United States. We're too good for that.
Thank you.
Thank you, Chris. We'll go to Takata and then Joseph.
Tēnā koe, Chris. The principles are being talked about a lot, and in my view, they're being sort of painted as the bad guy and helping to generate all of the discussion, and which is largely misinformed. Now, I'm probably a little bit privileged in that I've had a very clear explanation of where and how the principles come about from Tai Hakure. So I'm just asking, I want to ask you if you can give us some clarity on where and how and why principles come out of Te Tiriti o Waitangi.
Well, there aren't many principles, and they're all reasonably benign: to act with dignity towards one another, to properly consult tangata whenua, to protect their treasures and so on. I don't want to send you away to do your homework, but many years ago, Doug Woollerton, the New Zealand First MP, introduced legislation to delete the principles of the treaty from the legislation. And I was in opposition at the time and gave what I thought was quite a good speech summarising the principles. And so you may want to go to Hansard in 2006 and dig those out. But look, they're pretty innocent principles. They've been interpreted in a very conservative way by the judges over the years. And this really is a case of much ado about nothing.
For someone who is not a lawyer, aka me, what does this mean for settlements, and what does this mean for jurisprudence if this bill were to come through via second reading or via a referendum?
Oh, that's actually a very interesting and very lawyerly question with respect, because one of the issues that may be raised is if there are certain rights which are confirmed on settlement, and I refer particularly to the Ngāi Tahu Claims Settlement Act 1992, be very careful what you wish for, because it may give Ngāi Tahu a lot more authority in and over Te Waipounamu than Mr. Seymour and his cohorts intend.
Thank you, Chris.
That has been the subject of some comment in recent times, but it's an excellent lawyerly question. You should go away and see the commentary that's been written on that.
Thank you, Chris. That's the time we've got. I'm not sure something called lawyerly is often a compliment, but I think in this instance it definitely is. So appreciate you being with us this morning and wish you the best. Thank you, Jane. Thank you for being with us. I think you two are also familiar with the process, so I will invite you to present your submission for the next 10 minutes.
Kia ora. Thank you. The issue about the referendum. It was extremely concerning in the Waitangi Tribunal to hear that the officials have been asked in parallel to this process to be working on implementation of a referendum approach on this bill. Now, we hear this bill is not going to proceed, but that doesn't mean a citizens-initiated referendum cannot be instituted and an attempt to have that at the time of the next election. And already the cogs are moving in that direction. That is a major problem. The second is that even if this bill fails, as we've been told it will, the Regulatory Standards Bill, promoted by the same minister in a manner that has been completely antithetical to what are supposedly best practice regulatory approaches, would effectively write Te Tiriti o Waitangi out of the priorities in the lawmaking processes. And so I think you will expect to find there is an equivalent move on that that occurs irrespective of what happens with this bill. And the coalition agreement, unlike this, which says taking this bill to select committee, although David Seymour's remit is and passing it, the regulatory standards bill is to be legislated. And so I invite the select committee to seriously consider the implications of that for Te Tiriti o Waitangi. Kia ora.
Your 10-minute submission.
Thank you, Mr. Chairman. Tēnā koutou katoa. Shifts. I'm kind of had my breath taken away this morning and this afternoon listening to people, as if codifying something into law means that time stands still. One of the reasons we have the judiciary is to take account of the fact that Parliament never keeps up, and Parliament especially never keeps up when it's about people's rights. And the Minister this morning reiterated that the bill is his belief, and what one man's ontology and epistemology mean to him is not a basis for constitutional change. So the bill appears to take for granted that equality and rights is the same old we are all born equal rubbish. If you're interested in equality and rights, the foci are outcomes and results. So what should equal protection, benefit, enjoyment mean? Well, whatever Hobson's choice say, fortunately, Western democracies have embraced and recognised the practice of substantive equality. And substantive equality is not a concept, it's an analytical framework. Now, where a person or peoples have been subject to socially constructed, historic, systemic and systematic, accumulative disadvantage, equality cannot be achieved through equal treatment. And there can be no question but that iwi and hapu in Aotearoa have been subject to socially constructed, historic, systemic and accumulative disadvantage. You address this through substantive equality, through equality of outcomes and equality of results. And for an earlier person this morning who wanted to know, where's substantive equality work? Well, it aims to change and transform discriminatory practices. There are plenty of examples of abuse in the European Union, the European Court of Justice, the Supreme Court of Canada, acting on their Bill of Rights, the South African Constitutional Court. Substantive equality aims to change and transform systemic discriminatory practices. Equality is never achieved through equal treatment. Thank you, Mr. Chairman, for the opportunity to expand on my submission.
But, I mean, this does go to the essence of the problem in that the British relied on this English so-called translation, which beared no relationship to what Māori had signed up to in 1840. And Māori had entered into a relationship that they assumed was based on reciprocity and partnership and good faith and so on. It's been the raid on Mangapahatu in 1916 has been described as the last shots of the New Zealand Wars. So there's a long history here in terms of the disjunction between, as I say, the so-called English translation and what Māori actually agreed to in 1840.
Thank you. Māori, I mean, observation.
Thank you, Mr. Chair. Tēnā koe, Dr. O'Malley. You said warts and all, and talking about this whole, the have to have that knowledge, or that there is a knowledge gap. I'm using the word knowledge gap. In your mind, is it, could it be that simple? Is it that simple an issue that could actually be filled if we fill that knowledge gap that we find ourselves here, simply because people just don't know? Can it be that simple?
I think that's a huge part of it. I'm not saying the process of learning is going to be easy, because for some it's deeply uncomfortable. You're learning those stories about, you know, what your ancestors may have done in the past. But the thing I always say is the purpose of learning that history is not to make anybody feel guilty or ashamed about the actions of their ancestors. It's to ensure that we can carve out a path ahead for our future. We know where we've come from. We need that. We need that grounding. We need that identity. And that can only come from being honest with ourselves, I think.
Yeah. Thank you, Dr.
Thank you, Dr. O'Malley. Thank you.
I'd like to start that NZNO requested to be heard in person on the Treaty Principles Bill because we have grave concerns this proposed legislation will worsen Māori health outcomes. This legislation plays with Māori lives. It says it's okay not to give attention to the need to fix the health system that is killing our people. Tangata whenua are not the enemy. They are not a threat to this country sector where Māori are more likely to suffer from preventable illnesses, comorbidities, and shorter lifespans. Te Treaty provides a foundation to fix the serious and dire health problems faced by Māori.
Yeah, words such as, and you might have just touched on it, Sarah, closing that answer, that we get preferential treatment. Māori get preferential. The minute people hear generally, the supporters of the bill anyway, talk about Māori for Māori, it's an instant reaction, an allergic reaction nearly to that means that it's preferential. We get additional rights or resource or whatever it is. Can you just talk to that? How does that you feel, think?
I've been a nurse and a midwife and worked in the health sector for over 30 years. And certainly those comments of preferential treatment are not part of what I see every day. The struggle for those that use the health system, and in actual fact, the reverse. Māori are not privileged within the health system. The Y2575 recommendations and our nurses that gave evidence clearly demonstrated Māori are not given preference within a health system. If anything, Māori are struck off. Māori are turned away from ED departments. Māori are not having the same access. Māori can't afford to access and go to doctors or go to clinics. So the worsening conditions is perpetuated. There is no privilege within the health system.
If that's true, then if those conditions that you've just referred to, that is simply because we're lazy, we don't do enough, we're too fat, blah, blah, blah. That thinking heads down that pathway of thinking, and therefore it is simply our fault. The state of it is our fault. We get here because we don't do enough, and all of those horrible but silly things, but they get said, and then they get believed, and then they get embedded in the stuff that we're having to deal with like today.
And what a lot of Māori nurses that work within departments will tell you is that prejudgment often is deeply entrenched in the behaviour within the practice, within the system, within the attitudes and professional people as well. So our people will not go to services because they know that that's what they're going to get coined with, that it's your own responsibility, that you should be able to afford and the treatment that's necessary. That is far from the truth.
Thank you. Thank you, Kerry. Thank you, Paul, both for joining us this afternoon. We appreciate both your patience and your
Ko Ganesh Ahirao tōku ingoa. I'm a first-generation New Zealander born in Aotearoa to parents who immigrated here as young newlyweds from India many decades ago. I am proudly tangata treaty. I also wish to acknowledge and mihi to the many tens and indeed hundreds of thousands who will not get such an opportunity to be heard here. I feel privileged in this opportunity and feel their weight on my shoulders, but also their wairoa in support of and lifting me in this kaupapa. In addition to my written submission, I wish to emphasise that this bill is not and should not be treated by this committee as any ordinary bill. It requires more than standard processing. Your task is so much more than that. And this has caused considerable hurt and harm to Māori. It has magnified, emboldened, normalised and legitimised racist thinking, actions, attitudes and understandings that have hurt and harmed all in Aotearoa, tangata treaty and tangata whenua. I acknowledge that several leaders have said this bill will not proceed beyond this committee stage. That may be so, but that is wholly and totally insufficient. The hurt and harm has already occurred and is continuing to occur. And there must be concerted and genuine efforts to repair the bridge between Māori and the Crown.
with broad connections into multiple church communities, we can give you a sense of the strength of feeling among the church in support of Te Tiriti and against the Treaty Principles Bill. We are the organisation that coordinated an open letter from church leaders stating they oppose the intent of the bill and appealing to all MPs not to let it get to select committee. At the time, 440 church leaders signed, including the most senior leaders of Catholic, Anglican, Methodist, Salvation Army, and Pentecostal denominations. The number of signatories is now over 600 church leaders, which to our knowledge is the largest collective action or political statement by church leaders in recent history. The letter stated, "We affirm that Te Tiriti o Waitangi protects the tino rangatiratanga of hapu and iwi. The proposed bill is inconsistent with Te Tiriti o Waitangi in that it does not recognise the collective rights of iwi Māori or guarantee their relationship with the Crown. It would undermine what Te Tiriti guarantees and what decades of law, jurisprudence and policy have sought to recognise."
So to follow on from what Kate said, why is there such a strong feeling from Christians on this issue? Well, Christians are the inheritors of the legacy of the missionaries involved in the drafting, promotion and signing of Te Tiriti o Waitangi, and so we acknowledge a duty of care for upholding the mana of Te Tiriti o Waitangi. Like many other Christians, we see Te Tiriti o Waitangi as a covenant, a sacred promise of relationship. It is not just a legal document between the Crown and Rangatira, although it certainly has important legal obligations that flow from it. Jesus said, "Let our yes be yes and your no be no," and so our words and promises need to mean something.
We want the partnership to thrive. The Treaty Principles Bill breaches that partnership. Te Tiriti is an embodiment of the partnership between tangata whenua and tangata tiriti, where those people are committed to ensuring the best for each other in respect, equality and kotahitanga. This partnership model is the foundation for a flourishing, peaceful life in New Zealand for all. It is a Kiwi constitutional expression of loving your neighbour as Jesus commands.
I'm not going to go through my presentation because I understand that you've all read it. But I just wanted to briefly introduce this time before questions. In reading through some of the other submissions, in particular the Maori Council submission, they asked the question, what is the problem? So I thought I should start just briefly there. And it's really a set of questions. And the question is this: how did we arrive from 1975 Treaty of Waitangi Act with its idealism and its constructive nature and the success it brought, and end up now being a country that where we find that we spend millions of dollars playing whale songs to kari trees to check whether that will in any way cure kari dieback. How did we go from the brilliant settlement that Ngāti Whātua achieved, and then their extraordinary success, their investment success, and then end up being a country where professional bodies such as land agents have to go through obsequious, trite courses on to be a Te Tiriti partner?
There's been a lot of talk about sovereignty, cessation, yes, no, the other thing. But internationally, if we really get down to it, if there's indifference in interpretation of the two treaties that our country deals with, then through a act of international treaty law called contra preferendum, the Indigenous language version wins out. So I'm just wondering if you can point out for me in the Māori text of Te Tiriti o Waitangi where Māori cede their sovereignty.
I think the easier way to do it is just to simply say, could you point out to me at what point Tamati Wakanini did not understand the ceding of sovereignty?
The text is the text. The text is the text. It's what we have to deal with. Sorry, the text is the text, so it's what we have to deal with.
He signed the text.
People said a lot of things, but I'm just asking you if it's in there in the Māori text somewhere.
I would have thought clause 1's clear enough for you using the Ahiraro translation.
Or just again in the Māori text, if you can point it out, that'd be great.
I've just pointed it out with the Ahiraro translation.
Is that the Māori
You don't
text?
want to hear my I don't intend to speak to you in Maori. Wonderful language, but it's not something that I'm,
Okay, folks, is there any further questions for Paul?
No.
Thank you, Tim.
So Paul. So Paul, my question is, in your submission you've written to claim that anyone by accident of ancestry can enjoy special rights is repugnant in any democracy, you know the rest. What makes it so repugnant? Because there are heaps of democracies that have special rights, whether it's language, race, religion. So what's so repugnant about New Zealand doing what is actually quite normal in other democracies?
I don't think it is normal. I think in most democracies it's pretty clear that you shouldn't have specific rights based on your ancestry.
But do you understand that other countries do have special rights based on things, not just race, also language and religion and a whole lot of other factors, that's normal?
I don't agree with that. I think in most Western democracies it's a standard principle that your political rights, particularly political rights, are completely not related to your ancestry.
Okay, I'll send you some links.
Yeah, kia ora e hoa. Hey, I've just got a simple question. Do you think that Te Tiriti o Waitangi gives every person in this country the constitutional right to be here?
Yes, it creates the document that creates the government of New Zealand.
But does the constitutional right come from the treaty?
No, the treaty is the foundational document for creating the government of New Zealand.
But the constitutional right comes from the treaty.
Well, actually, the constitutional right for me to be a New Zealander is that I was born here.
I didn't say New Zealander. I said in the country.
Well, yes, if it's...
Kia ora, thank you.
Tēnā koe, tēnā koutou katoa. My name is Elliot Ewan Pasione Ikile, and this is my colleague, Thomas Newman. Now, before moving into our commentary, we also want to bring up a public point here, which is we learned this morning that Hobson's Pledge had not been given a time to present. This is outrageous when you consider our leading voice and the tens of thousands who support us. We want to thank Democracy Action for giving us their spot that was done pre-hand, which was done beforehand. We were expecting to be given a voice on Thursday. That didn't happen. We also want to thank those staff members and the clerk for being able to confirm that we were indeed here as per Democracy Action's brave sacrifice. Again, Mr. Chair, it is incomprehensible that we would not have a voice to speak at.
Thank you.
Thank you, Elliot. Thank you, Tom. So just to clear up a perceived misunderstanding, Hobson's Pledge was invited in the first emails that went out to make a submission, and unfortunately they weren't able to respond by the deadline, and so those slots were filled up by those submitters who did respond. And
It's possible we have a severe miscommunication.
Very good to
We've been
have you
very
guys
much
here,
on
and
with it
we
every point.
appreciate the time that you took us to that point. So thank you.
Special treatment.
Folks, we're going to move on now. Let's see
Thank
the
you, Mr. Chair.
context.